Okay, it's 11 o'clock, so we're going to go ahead and get started. First off, I'd just like to say good morning to everybody and thank you for joining us. My name is Kimberly Hobbs. I am the Executive Director of Central Alabama Fair Housing Center. And on behalf of the center, we would like to, again, thank you for joining us for our, as we celebrate the Fair Housing Month. For those of you who are unaware, April is Fair Housing Month, and this year marks the 53rd anniversary of the passage of the Fair Housing Act. It's a time to commemorate and to celebrate the passage of the act, as well as to reflect on the work and the victories that have been had, and those who led this work before us, as well as a time to focus on the future and the fight for fair housing that we still need to do and all of the work that is still need to be done. And today, it is my pleasure to introduce to you Mr. John Pollock. He is the staff attorney for the Public Justice Center, where he works, where his work focuses on establishing the right to counsel for low-income individuals in civil cases involving basic human needs such as child custody, housing, and benefits. Since 2009, he has served as the coordinator for the National Coalition for Civil Rights, for a Civil Right to Counsel. And he has a long history in the fight for civil rights and in housing. Prior to joining the Public Justice Center, he actually served as the enforcement director here at Central Alabama Fair Housing Center. And before us, he was a law fellow at Southern Poverty Law Center. And while he was there, he founded the Heirs Property Retention Coalition in Montgomery, Alabama, which is a network of organizations across the Southeast working on stopping the forced sale of ancestral, is that right, property within low-income African-American communities. Today, he's going to speak with us about combating housing discrimination, evictions, and heir property. And just a little housekeeping, if you have any questions, please don't hesitate to ask. There's a question and answer box down at the bottom, and we will interrupt him and ask your questions at any point in time, okay?
Thank you, and it's a pleasure to be here this morning talking about two really important topics that both have an overlap with fair housing concerns. So I'm going to share my screen now because I have a little presentation to show you all. And as Kimberly said, feel free to ask questions as we go along. So what I'm going to do is talk to you a little bit about heirs property, how it works, and particularly how it's a real scourge for disadvantaged communities and particularly communities of color, and how it impacts housing. And then we're going to sort of transition to other housing issues that are a major problem in this country. So basically what heirs property is it's not actually a legal term, but it's basically a term for when someone passes down property and it winds up being owned by more than one person after it's passed down. And usually that happens because someone owns property and doesn't write a will. And then when they die, their children or their other heirs inherit the property kind of equally. They own the property in equal percentages, but there's no like dividing line in the property so you can know who owns which piece of it. And it's really, we're going to show some numbers on just how big an issue heirs property is. Sometimes it's called tenancy in common, but usually in communities, they call it heirs property or heir property. That's the term you'll hear affected communities call it. And as I mentioned, it's created often without creating a will, although actually if you were to have a will that just said, I passed my house and my property down to my 3 children, then that would actually create heirs property too, because that all would be owned equally by your 3 children, and there wouldn't be a divisible line between them. They wouldn't know which part of the property they own. They would just own it co-equally. And the reason why it's hard to stop, and we're going to really go into detail on this, is that once the property breaks apart into these pieces, like once you have these 3 owners, let's say you have, a person who dies and they leave, their land, let's say they have farmland or other land, and they leave it to 3 of their heirs, and then those heirs die. Let's say each of them has 3 children. Now you have 9 heirs, and then another generation after that, you could have 20 heirs or 100 heirs or 500 heirs. And that's actually what happens, as land is passed down over decades and centuries. You start a single piece of property, and it's really difficult to actually reassemble the land once it's been broken up like that. And as we're going to talk about, there's also an issue with myths that basically that communities have about the way heirs property works that actually cause the problem to become even worse. So basically, as I was saying, like the way that heirs property is created here in Alabama is our state law says, like, when someone dies without a will, here are the people who stand to inherit. And it may be children. If there are no children, it can go to spouses or cousins. And the law sort of dictates all of that, how that's going to work. And each owner gets what's called a fractional undivided interest, and that they're not able to point to where their specific share of the property is. And what's really hard about combating this problem, the problem of heirs property, is that there are some beliefs in communities about how heirs property works that are not accurate. And those cause people to not seek out legal help to sort of stop heirs property from forming or deal with the problem once it's been created. So, like, for instance, there are many people that think, oh, you know, my property, there are 10 of us who own this property or 50 of us who own it. So there's no way we can lose this because someone would have to buy every one of us out in order to get the property. That's not the way it works. And we'll talk about why it doesn't work that way. But basically, it's actually the least safe form of ownership, not the most safe form. Another one is that if you have a will that heirs property isn't created, well, that it has to be done a will has to be drafted the right way in order to stop heirs property from being created. Some people think that if they pay the taxes, they say, oh, you know, I'm the one who pays the taxes on this property, the property taxes, so I own the property. That's not how it works. Paying the taxes does not give you any more of an ownership right than any other co-owner of that property. And same thing about living on the property. You may have lived there for 50 years. There may not have ever been another soul on the property that's ever stepped foot on it. That does no relevance at all to whether or not you have a better ownership right than the other co-owners of the property. The fact that you're living there alone doesn't mean there aren't other owners of that shared property, that property isn't a shared property. And sometimes people think that doing a land survey solves the problem. It doesn't. And without going into details, I'll just say that that's just another reason why heirs property sometimes doesn't get corrected. And these myths actually have a real-time effect. You know, basically, as you can see from this article from the New Yorker, it says, you know, many assume that not having a will keeps land in the property. In reality, it jeopardizes ownership. It's actually like heirs property often works the opposite of the way that people believe it does. And so that's actually a really significant problem when it comes to dealing with it, because we have owners who are not seeking out legal assistance and not seeking out help because they don't think they actually have an issue that needs to be addressed. And that's one of the things that we work to combat in having educational sessions kind of like this one. So what happens when you have the heirs property? Like why do we talk about, okay, so you have all these owners, what kinds of problems does that create? Well, one of them is after a period of time, no one may know who's paying the taxes anymore, and the property may wind up getting lost in a tax sale, because if the taxes aren't paid, the government can actually put the property up for auction, and someone who pays the unpaid taxes can wind up owning the property. Another one is partition actions. And what a partition action basically is, and we'll talk more about these in a little bit, is basically any one of those owners, if you have 50 owners, any one of them is allowed to go to a court and say, I want this court to force a sale of the whole property, and put the whole property up for auction. It does not matter whether that owner owns 1/1000th of an percentage of an interest. It doesn't matter if they just became an owner yesterday. They have the same right to do that as any other owner does. And a partition sale, if the court orders it, the property goes up for auction. Whoever buys it can basically boot everyone off of the property. It dispossesses everyone else that was an owner, no matter how long they owned it, no matter how big a share they owned. And so partition sales are a really, really big problem that heirs property creates. And then another problem is, because everyone has an equal right to use of the property, it can create conflict as far as different owners having different ideas of how to use the property. And also, some owners may use the property and start making a profit off of it and not tell the other owners they're even doing that. They may use it for timber, they may use it for mining, they may use it for whatever, and then they're not sharing the proceeds with the other owners. And then another problem is access to equity, which is that you may have a property that's worth $1 million, and the owners may all be what we call land rich and cash poor. They may not have any other resources other than the land, but they can't go to a bank and say, we own half of this property. We want to draw out the equity. The bank is going to say, you don't have clear title of this property. We're not going to lend you anything off of your 50% interest. You have to have a whole interest in the property. We're not going to sell. We're not going to give you more, we're not going to give you a mortgage, or we're not going to lend you money. So it can be, owning a land in this fashion can basically lock value into the property in a way that can't be accessed. So actually, these properties, and this is an example of a partition sale story. These are problems that happen. And I like this story also because, you don't think of New York as a place where this kind of problem happens. In fact, this happened in Queens, not even in rural New York. This was in New York City. You can have heirs property really anywhere, as long as the property's been passed down in the way that I've described, and you have multiple owners, people's property can be vulnerable. And in this case, there was a man whose brother sold their interest in the property, and then the developer basically tried to force a sale of the rest of it using the partition action that I described before. So these are real problems with real consequences. Why we're talking about it, especially during Fair Housing Month, is that this heirs property problem has a particularly significant impact in Black communities, which is one of the reasons that my coalition got started, is because of that seeing that problem, especially here in Alabama, but really throughout the South, it exists. One estimate that was done is that about more than half of the heirs property owners that exist are Black, which is astounding when you think about it, when you talk about like a national average, and that that the low will writing rate in Black communities, and one estimate said that 81% of the earliest Black landowners didn't write wills, which shows why this problem has continued on for so long. And that one of the reasons why in Black communities the will writing rate is lower is because in those communities, lawyers were often responsible for dispossessing them. They cheated them, and there's really no other way to put it, that lawyers cheated Black landowners out of property for decades, centuries, really were responsible for land loss in many of these communities. So a lot of communities don't trust lawyers of any persuasion. And so they're not going to go see a lawyer to write a will. And that's a big problem that contributes to heirs property. Some of them may want to seek an attorney, but they don't have the money to hire one to do estate planning. And then also the prevalence of oral traditions in especially rural Black communities, information other than writing, and that includes ownership of property, also contributes to the lack of wills and the creation of heirs property, and then the prevalence of all the myths that I discussed before. And how this has played out in farmland, Black farmland especially, as you can see, what has happened to Black farm ownership over the decades, that basically it has dwindled. At one point, it was predicted, I think, that there was about 16 million acres of farmland that was owned by Black farm owners, and now you're looking at basically 1.5 million. So just a dramatic decline. And the USDA actually said that partition sales were one of the reasons why there's been such a decline in Black farm ownership. So now we're going to, get to partition sales, and I'm going to talk a little bit about that because that's where we've been able to have some of the biggest impact. As this was a recent New York Times article that talked about what we've often called partition sales is essentially legalized land stealing. It's a process that really does not take into account how long people have owned the property. It doesn't take into account whether they've used it for non-economic purposes. It doesn't take into account really anything fair. It's just basically a very inequitable system that allows land speculators and others to force poor people off of their property. And as this article said, it talks about partition sales, and it says, that instead of probating the wills, Black property owners tended to bequeath their property to descendants in the form of undivided shares, and then search for a person who had inherited land this way and buy out one of the interests and then force a sale. So this has been going on. Partition sales have been going on for decades and decades and decades. part of the problem with partition sales is that there was, going into the thing I'm about to talk about, there was no state that actually handled partition sales well. Like basically all the laws didn't protect against the kind of predatory actions I'm talking about. It didn't take into account any sort of principles of equity. It didn't require that the property sell for a fair value, basically. And in fact, studies have shown that these auctions, the property sells for a tiny percentage of what it's worth. And a lot of vendor will buy a property for 10% of its value, and then a week later will sell it for its full value. And that's because the owners, often who are living on the property, don't have the resources to bid against the speculator at the auction, so they wind up losing it. And then, on the ground, when the owners go into these partition sales, they don't have lawyers. That's just a fact. And what we've seen is that when they actually do manage to hire a lawyer, it actually is the single biggest factor about whether a court orders a sale or not. When landowners are able to find a lawyer, when they're able to hire one, these auctions don't wind up happening. So that's just what we've seen in practice. And then they don't have the resources to buy the property at auction, like I was talking about. And then you have these crazy ethical issues where you have the attorney who represents the speculator. The court will often hire that person to conduct the sale for the property, which is just an inherent conflict of interest. The courts are supposed to weigh, is it possible to divide the property among the owners? And they almost never do that. They basically just don't do it. And so even where the law has provided some protections, the courts have not really been executing them because those protections are not worded very strongly, and they just haven't been followed. So what did we do what was the solution to this? Well, basically the coalition that Kimberly mentioned that I created, the Heirs Property Retention Coalition, came together because of this, because the problem of heirs property and the scourge that it presents for minority communities was one that was so big, and we were trying to figure out what is a place of this we can change. Trying to stop heirs property from being created is really, really difficult. And we did do some of that through doing education sessions around the states, trying to educate owners about the myths, trying to encourage them to write wills and do all of that kind of thing. But trying to stop partition sales was the best way to stop the bleeding, to try to stop more land loss from occurring every single year. And so what the Uniform Partition of Heirs Property Act does, and I should say it took us 3 years of working with the Uniform Law Commission to create the Uniform Partition of Heirs Property Act. And then once it was created, we had to get states to actually enact it into law. And what the Uniform Partition Act says is, if there's someone who goes to a court and says, I want to force a sale of the property, before they're allowed to do that, they have to offer their share of the property to all the other owners. So if they own 10% of the property, the other owners are allowed to buy out that owner trying to force the sale. And if they do, that's the end of the action. So that really, it gets the owner that wants a sale out of the picture, and it keeps the other owners in possession of their interests. The second thing it says if a buyout doesn't happen and the court is trying to weigh, do we divide or sell the property? The courts can't just consider, what will happen to the property's value if I divide it, which is all they look at right now. It requires the court to say, well, what are people using this property for? Does it have ancestral value? Does it have community history value? Are the owners using it for non-economic purposes? Are they using it for reunions? Do they have a sentimental attachment? And the courts have to consider all of those things in considering whether to divide or sell the property. So that really restores equity to the process. And then if the court's going to order a sale, it has to order the sale to be done through a realtor or similar sort of market process, not just posting a notice of an auction on a courthouse door, which is what happens now or what happened before, but basically says the process has to be marketed, and that there are some requirements about selling the property for full value. So basically it ensures that if you are going to dispossess owners, they're at least not going to get cheated out of what the property is worth, which is what currently happens. And where we are right now is that we've had, I think we're up to 18 states that have passed the Uniform Act. And I can tell you that those states include Alabama, Georgia, Arkansas, Texas, South Carolina, Mississippi. We have done really, really well in the South, in the states that we cared the most about, the ones that we were really focused on. The list that you see on the screen is not a complete list. You can see it's cut off, but this is a partial list of the states that have adopted. And as you can see, there's a bunch of states that are also pending right now that it's still going to. So we're having really great success in getting this partition law to try to stop this dispossession of poor, very poor, and predominantly Black landowners across the country. One other really nice thing that happened in 2018 is that our senator here, Doug Jones, our US senator, got a provision into the Farm Bill that said that if states adopted the Uniform Partition Act, that it would actually unlock more federal funding to farmers, basically. And that actually, doing that basically has encouraged a lot of states to pass the Uniform Act, especially states that have a lot of farmland that weren't really concerned about this before, are now actually looking to pass this act so that they can actually tap into more federal funding for farmers. And so that's really, that was not something that we knew was going to happen. It was kind of a surprise, although some of our coalition members did work on that, on getting that with the senator on getting that provision into the law. So that's been a real boon. One other thing I'll mention about this law, that just in terms of how it played out in real life, is that in Hawaii, which was a state that passed the Uniform Act, Mark Zuckerberg, who, as you may know, is the founder of Facebook, actually filed some partition actions to try to force some ancestral Hawaiians off of their property. And this was, again, it's property that had been, owned for a very long time by native Hawaiians. And he filed these suits to try to get the owners who owned the property around his property. He was trying to buy all the property around him so he could, I guess, maintain his privacy or whatever he was intending to do. And when he filed his actions, the Uniform Act passed in Hawaii and was set to go into effect on January 1st of the, I don't remember what year it was. And he filed all these partition actions on December 31st, basically the day before it went into effect, because he was trying to avoid our act. He didn't want to have to comply with what it would require him to do. And so he tried to avoid it. And fortunately, there was such an outcry over this, dispossessing Native Hawaiians of their property that he wound up reconsidering his action and wound up abandoning most of his partition actions and didn't pursue them. So, and then just as a result of, I talked about New York before, and after, as a result of starting to see these partition actions in New York City, the state wound up passing the Uniform Act to try to crack down on these homes being lost, even in New York City. So, where we are, basically on this issue is that, like, the heirs property, this is, for many people where they live. It is, this is not just property they own. They often have homesteads on those properties. So when they lose these properties to tax sales or for partition or whatever, this is massive, housing loss. And so, again, we're talking about communities of color that are the ones that really suffer the most from this scourge. So we really see partition and heirs property problems as a fair housing problem. And that's why trying to resolve it is a fair housing concern. So what I then wanted to talk about is, what other fair housing, how else do we think about fair housing issues in other contexts? Well, and I do a lot of work in evictions, so I'm going to get to that because that's where we're seeing a lot of fair housing issues play out right now. But what you have in this country is, as you look at sort of the housing market writ large, you have you start off with like a wealth gap, that basically when you have renters or buyers in the market, people of color have far less money available to them, both in terms of income and in terms of savings, because of decades and centuries really of discrimination in employment and farm lending, land loss of the kind I described to you, and other factors. Basically, people of color have less accumulated wealth, and they have lower earnings per dollar than white people in the same markets. And so they're coming into these markets with less to begin with. And then you start dealing with this, historically de jure residential segregation, which was when de jure meaning by law, essentially, for a long time, segregation was literally, mandated. And then even when it wasn't mandated, it started happening through tactics like redlining and blockbusting, where realtors were basically saying, I'm not going to rent to anyone or sell a home to anyone in this neighborhood. I'm not going to rent to a person of color in this neighborhood. I'm not going to sell a home in this neighborhood because I want to keep it all white. I'm only going to rent to them in these other neighborhoods. And that, perpetuates not only segregation, but also, when you concentrate poverty, it then, you have fewer resources in that community, and that leads to, other issues as well. So it leads to other fair housing concerns in addition to the initial discrimination. You also have environmental racism, which is, factories and companies dumping chemicals more heavily in communities of color than they do in other places, which leads to huge health problems, which leads to lower income, which leads to housing problems. And so you have just all of these factors. And then, banking discrimination, which we really saw around the 2008 housing crisis, where there were all those foreclosures. And we found out that, in fact, a lot of banks had been steering minority borrowers into inferior loan products, basically, that even where people of color qualified for a higher loan, like a better loan with better terms, they were actually still giving them subprime loans with worse terms. And that, basically just based on race. And statistically, what we saw was that even when you were talking about higher income people of color, they were still being steered into subprime loans at a higher rate. In fact, in some cases, they were steered into worse loans at an even higher rate than lower income people of color. It was just pure discrimination, plain and simple, like no way to account for it other than discrimination. And then you have, besides these sort of systems of discrimination, you have the individual discrimination by landlords and realtors, basically saying, I'm not going to rent, I'm not going to buy, where it's not necessarily the whole industry, but you have individual actors that are contributing to the concentration of segregation and into neighborhoods with inferior housing stock. And then the disproportionate presence of people of color in evictions and foreclosures. I'm going to show some statistics about that in a moment. Even when you control for income, it's not just simply that people of color are more likely to be evicted because they have lower incomes to begin with for all the reasons I described. Even when you control for income, they're evicted at a disproportionate rate, which means that there's something else going on. Landlords' decisions about evictions are not just about money. It's also about race too, and also in foreclosures. So what is, the Fair Housing Act, and that's what this whole month is basically intended to combat a lot of the things that I just described. Its intent was to both end discrimination and promote integration. And it prohibits discrimination based on 7 factors. Some states have actually added additional factors to that, and they don't just use the 7 that the Fair Housing Act has. And importantly, it covers disparate impact, not just intentional discrimination. So it's not just about, well, these things happened, but we weren't doing it intentionally, so we don't have to worry about it. The Fair Housing Act says, no, actually, cities and states cannot ignore if the net effect of their policies is to cause a disparate impact on communities of color, then that can violate the Fair Housing Act too. Enforcement of the Fair Housing Act is through HUD, or it can be also enforced privately, but it's actually very difficult to prove housing discrimination has happened. The Fair Housing Center uses testing to do that, and there are other ways to do it too. But I will also say that the lack of counsel in these cases, the Fair Housing Act can only represent a portion of the people out there. The Fair Housing Center can only represent a portion of people out there. There are many people who don't have access to legal representation to identify these claims and to bring them. So the lack of counsel, which I'm going to talk about in the eviction context, is a big issue for the fair housing enforcement as well. When it comes to evictions, we're talking about a major scourge. We're talking about a problem where 3.6 million evictions are filed per year, and that was before COVID-19. During COVID, we were looking at about 40 million tenants that were at risk of eviction and would have really seriously faced eviction if it had not been for a moratorium on evictions, if it had not been for $1 billion of rental assistance, if it hadn't been for increases in tenant representation that were provided to try to stem the tide of all these evictions. Nationwide, only 3% of tenants have counsel in evictions compared to 81% of landlords. And there are massive racial disparities as far as who goes through eviction proceedings. And that's what I want to show you now. This is, again, why we consider evictions a fair housing problem. This is data that the ACLU put together from the Eviction Lab, which compiles national eviction data. And it found that in half the states they looked at, Black female renters, not just Black renters, but Black female renters faced eviction at twice the rate of white renters. So that's just a massive disparity of people going through eviction, twice the rate. That's just such a huge disparity. And during COVID, as we've been tracking, who's been saying, this particular chart looks at, it calls it confidence level and ability to pay next month's rent by race. So the top chart is the confidence level of Black tenants in their ability to pay rent, and the bottom chart is the confidence level of white tenants. The red and orange bars are basically people who have little to no confidence in the ability to pay rent. And if you look at the red and orange bars on the top chart, they're at least twice as large as the red and orange bars on the bottom chart. So you're talking about a gap of at least twice, and sometimes 3 times as likely to say that they're unable to make rent. That disparity also exists for Latinx tenants during COVID. It's been about 2 times as much as well. And what's really problematic about this gap is that you have COVID itself has ripped through communities of color at a much higher rate than its decimated white communities. So they're already facing a health crisis that has a disproportionate impact. And that in turn puts them into an eviction machine where they were already affected at a disproportionate rate. So just a combination of absolutely devastating combination of circumstances. So what are we doing to fight evictions? Well, the work that I do is on Right to Counsel. I'm happy to say that we actually have made incredible progress in the last 4 years, having gotten 9 cities now in 1 state, Washington State, to pass a Right to Counsel. Maryland's bill is almost passed. It's just waiting the governor's signature. And we actually just got news that Connecticut's bill got a big boost recently. But you can also see that there have been bills filed in a number of other states, including South Carolina and Indiana. So some, maybe not typical suspect states. I should just say what a Right to Counsel means is that if a tenant is being evicted and they cannot afford a lawyer, that one will be provided for them by the government, the city or the state, at no expense to them. So basically similar to what you might be familiar to in criminal cases. They would be provided that in their eviction proceeding. In some of these jurisdictions, actually, it's provided to everyone regardless of how much money they make. It's just everyone. But in some of them, you have to qualify based on income. And then we have a few places that are looking to introduce in the coming months. And then there's also been this tremendous interest at the federal level by a number of senators and House members on Right to Counsel. Why? And then, this is just a sample of other places that are looking at Right to Counsel. I just was on the phone this morning with some folks in North Carolina. We have not really had that conversation here in Alabama yet. Unfortunately, I have not heard of really movement on this in Birmingham or Huntsville or Mobile or Montgomery or any of the major urban areas. But we're hoping that that interest will start to come down here more in the South. I will say that actually, I'm sorry, I'm missing one on this chart. Louisville, Kentucky was the most recent addition after Seattle, and it passed just last week. So that was our first Southern city that has a Right to Counsel. And one of the reasons why we pursue Right to Counsels, we know that when tenants have lawyers, they don't get evicted. In New York City, where tenants are getting lawyers, 86% of those who are getting lawyers are staying in their homes, which is really astounding success rate. And the eviction filing rate has gone down by almost 1/3. So landlords are not filing as many evictions because they know that the tenants are going to have lawyers, and they know that it's not going to just be a snap judgment by a court. They're going to easily be able to. Will be able to, they'll have to actually negotiate and potentially fight, especially if they're filing a frivolous eviction. There was a question about sharing the PowerPoint. I will be happy to do that. I will share it with the CAHFHC folks after the presentation today, and they can get it out to people who registered. One other thing I'll note about New York too is you can see that the default rate has dropped 34%. In housing cases, in eviction cases in America, about half of all tenants do not actually show up for eviction court. And that's a very complicated problem to analyze, but I can tell you that the eviction process is such a mill right now that most tenants know that there's very little point in participating, and they don't participate. And when you consider again that the people who are being evicted are predominantly people of color, that lack of participation is especially problematic from a fair housing standpoint. So when the right to counsel can reduce that default judgment rate, that can really help this problem. We also, the courts have also said like, hey, this is actually making like our courts fair and more efficient, which we, seeing that the courts are happy about it is a welcome development. San Francisco, which was the second city to pass a right to counsel, has had a 2/3 success rate of tenants staying in their homes. And as you can see here, even though they have no income limit, 85% of those who are getting counsel, who have applied for counsel, are extremely low or low income. So it's not like going to rich people. The people who are applying for their free lawyer are people who we would expect need it. And Cleveland, which just released their report, 93% of those who are represented have avoided eviction or an involuntary move. So this right to counsel is an intervention that really can change the whole dynamic of evictions. It can change the whole eviction picture. So that's my presentation for right now. And I have a little video which I can show. It's about Heirs property, but I wanted to stop now since that's a lot of information and just give folks to ask any questions they might have.
Okay, so before anybody else jumps in, I'm going to ask a couple of questions. I didn't want to interrupt you. I'm sorry. So while you were talking about the heir property and it not mattering if somebody lives there, one of the fun topics that they teach you in law school, and which I don't know anybody who actually practices on, is like adverse possession of property. So if you live on a property and you pay the rent and taxes, that you can essentially claim it as your own. Do individuals not have that argument, or are people just not making the argument for adverse possession in heir property cases? That's
a great question. Yeah, so what Kimberly's describing basically is in regular, just putting aside heirs property, if you're just talking about a regular piece of property, if someone lives on the property, let's say for 20 years, and no one ever sets foot on the property, and they put a fence around that just says keep out. I'm talking about someone who doesn't belong there. I'm not saying someone who owns it. I'm saying you have someone who goes onto a piece of property, no one's using it, it's essentially unused. They go onto the property, they put a fence around it, they say keep out. And for 20 years, they live on that property. Under the law in this country, in some states, they would be able to claim ownership of that property, and it's something called adverse possession, which is a very, it's basically squatters' rights is like another way to think about it. It's in order to do it, the law and how that works varies from state to state, but basically that's the general gist of it. So what Kimberly's asking is, well, if you have this heirs property owner who's done all of that, why can't they just adversely possess against all their other co-owners? Well, the law says in many states that in heirs property, any owner who occupies the property is doing it for the benefit of all. And so therefore there's like this fiction that they can't really adversely possess against the other owners for that reason. Now, there are some states that do allow it. It's not all the way. It really depends on the state as to whether or not they'll allow that kind of possession to happen. But one of the reasons we actually talked about trying to explore adverse possession as a way to try to clear up title, saying like, look, if we've got an owner who's been there forever, no one else seems to be involved, maybe we should try to, use adverse possession like that. The problem is that you have landowners who are out of state and know about the property. And it's like, for them, it's like, it's a connection to their heritage. Like, even if they never go, even if they never set foot on the property, knowing that their family owns property in Mississippi and they live in New York, it's like that carries value to them. So there's a potential to accidentally sort of dispossess owners who really shouldn't be dispossessed as you're attempting to, clear the title. It can wind up being kind of controversial. Texas actually did pass a bill a few years ago that allows the ability to adversely possess for co-owners like that, but it has very specific requirements to try to avoid sort of dispossessing the wrong owners.
Okay, I mean, it makes sense. I've never seen adverse possession used here, but it seemed like something that could apply. Mm-hmm. We also have another question, and that is, what are the top 3 things families can do to avoid conflict amongst themselves, besides a solid will when it comes to their heir property?
Yeah, that's a great question. And, this is sort of what I was alluding to before about the real problem with Heirs property is, let's say you have, someone who dies and they pass the property to their 3 children with no will. Those 3 owners now have heirs property. Even if each 3 of those owners writes a will, and even if all their children write a will, and even if all their children write a will, you can't. It's still going to be heirs property for all that time because of the first generation when it broke into 3 pieces. Like, you can't. The only way to put the property back together again is to, if you do something like create a limited liability cooperative and say we're going to give the property is going to be owned by an LLC, not by any one owner. That way, when the owners die, it doesn't affect the ownership because everyone just has an ownership interest in the LLC. No one actually owns the property directly. And there are other ways you can do it too, but you can sort of reconsolidate the property. But let's just say for the moment if you have heirs property, how you can govern that. Well, there's something called the tenancy in common agreement, a TIC. And a TIC basically says, here are the rules we're going to operate on. This is tenancy in common, it's heirs property. Here are the rules we're going to operate on. We're not going to allow a partition sale, or we're not going to allow it unless X happens, or we're not going to sell our interest without consulting the other owners. And there are ways you can sort of try to protect yourself by creating an agreement like that. You'd probably have to see a lawyer to get it right. It's not really something you can just draft on your own and hope that you'll just be able to use. You really need to get a lawyer to make sure it's done the right way. One of the tricky things about heirs property that we ran into is we've had some situations where owners have come to us and said, we want to fix the property. We want to create an agreement. We want to reconsolidate. We want to do all this stuff. And let's say they have a group of them, there might be 10 of them. And then there's one owner somewhere else that they don't know. It's a family member that no one's ever met, that they've never been anywhere near the property. You need all the owners to make it work. To basically protect the property, you have to have everyone in agreement, all the owners. And if you contact that one owner and tell them that they own heirs property, that may alert them to something they didn't even know about. And then they may seek a sale of the property because they suddenly find out that they have an ownership interest in something and they want their cash for it. So there's a sleeping dog's lie problem that we have with heirs property that can be really tricky to deal with. There's really no easy way to deal with that. You can have a mediator. And sometimes with heirs property, mediation is often a good thing to have because there are a lot of owners. They may have different ideas about what they want to do with the property. Some owners may want to sell. Some may want to, farm it out for farmland. Some may want to collect timber. Some may want to use it for reunions. You have to get everyone on the same page. You have to find a way. So a mediator can be really helpful. What we heard about, a lot of times families sort this stuff out during family reunions. That's the time they do it. In fact, a lot of them will meet on the property itself and sort of try to get everyone together to try to come to an agreement about what to do with the property. So, on the one hand, I would say the best way to, avoid conflict is to really have the active conversation. But again, there's that one risk. If you do involve people who are not aware of their ownership, it can cause problems in sort of risking loss. And that's a terrible thing to say, but we actually had a case in Alabama where that happened. We had a 200-acre property, 200 acres that was owned by 4 people. And we had 3 of the owners who came to us wanting to solve it. And when they sent a letter to the 4th owner threatened to file a petition sale. And that was obviously a very troublesome development, but that's what can happen. Now that we have the Uniform Act, that actually helps quite a bit because it creates a bulwark against really abusive partition actions that didn't exist before when we were originally dealing with this problem. Okay, the partition sales raised a question in my mind. Who, I guess, when you're saying some corporations come in and buy it, what are they using it for? Is this, could there be a fair housing argument and maybe a gentrification and displacement issue there? Or is that not what they're using the property for if it's not going back to housing, or what's happening? What they're going to use it for can really vary. It could be a shopping center. It could be a gas station. It could be, one of the things about heirs property is that a lot of the heirs property owners live in land that for a long time was not valuable because it was far from anything. And then you have development that starts to get closer, or you have an interstate that's planned. And interstates, that's one of the biggest ones. An interstate is planned, but no one knows no one in the community knows that. The developer knows that, the speculator knows that, and they know that in order for an interstate to be built, two things have to happen. First of all, the government has to buy the land along the interstate. Like they have to actually put the road down if they're going to extend it. So they have to buy out that land, which means it's going to be valuable. The second thing is that anyone who lives near the interstate, that land's going to become more valuable because stuff will pop up along the interstate, hotels, gas stations, whatever. So what they do is they go into communities far before anyone knows that the property is valuable, and they'll basically offer to buy it for pennies on the dollar. And then they turn around and sell it. So sometimes they're buying up land for that reason. They're buying and holding it for future development. Sometimes they have their own plans. They're going to use it for constructing some sort of business on the property. Sometimes they're going to use it for mining. Sometimes they're going to use it for timber. Sometimes, and they may know the value of the property far more than the owners do. As far as whether you could have a fair housing complaint against them, it would be pretty hard. I think it would be hard to prove like that they intentionally were discriminating against. I mean, if you found a company that sort of like only went into Black communities to do this, you might be able to show that there was some intentionality there or disparate impact, but you would have to show it on, I don't think on a single incident you would be able to prove much. You would have to show like a pattern of them doing it, in a certain area. And then you might actually have a fair housing issue.
Yeah, I know there's a lot of air property in our Black Belt that's tied up. And so just curious about arguments that could be made if it is an issue.
Yeah, and there have been studies done that have shown that there are, millions and millions and millions of dollars of value locked away in this Heirs property all over the South, just untold millions of dollars that families could, you're talking about families that are often very poor. They don't have anything, but they own this land. But they, like, for all the reasons I talked about, they can't get into it. Like they don't have the ability to get a mortgage. They don't have any resources to start a business. And even a timber company or something else may not want to lease with them if they think the title is unclear. So it can be really hard for them to use the value of their property, which is often why it gets sold. But selling it dispossesses everyone, so that's not a great solution. Like, it's basically the best solution is to like put the land into an ownership stable ownership. If you have the land in an LLC, the LLC can apply for a mortgage, and the bank will give it one because the LLC is stable. It's a single owner. The fact that there are many people who then own the LLC is of no consequence, because what matters is if you have, let's say 10 owners who have an LLC and one of them dies, it doesn't make any difference as far as the ownership of the property. Their interest in the LLC may pass down to many people, but that doesn't matter because the property is still only owned by one thing, the LLC. That doesn't change. So that can be, and there are other ways you can do it. It's not just LLCs. There are other ways you can reconsolidate also, but yeah, that it's really so distressing to see how much poor, especially minority communities in the South, are losing out to other people coming into communities and preying on them, essentially getting this, stealing this land. Really, there's no other way to describe it than essentially stealing their land from them. I used to call this problem the worst problem that no one's heard of, which is true. Like, people in these communities know about it. You'd say heir property to them, they're like, oh yeah, heir property. Like, they know about it, and they know about partition sales. But outside of those communities, there's not much awareness. Historically, there's not been a lot of awareness about heirs property. The Uniform Act really raised the profile of this issue. In fact, like, seeing stories in the New Yorker and ProPublica and the New York Times, that never happened before. Like, before the Uniform Act, there was never any media focus on this issue. The only time that the press had ever paid attention to it was one story in 2001 from the Associated Press called Torn from the Land, where they looked at loss of land in poor Black communities and the various reasons for it. But other than that one series, there's basically been no media attention to this problem until recently.
Yeah, so that goes sort of towards the wage gap or the wealth gap in America too, with you saying like that there are land rich, but they are still cash poor. With, I think a recent study with Zillow partnered with NAFA, the National Fair Housing Alliance, and they were saying that about the single biggest asset in a person's wealth is usually their home or land or property. And if you don't have access to that wealth, then obviously it's going to contribute to the wealth gap.
And we know also that, people of color rent at a higher rate than white people do. And so they're not accumulating equity in their homes at the same rate. It's just like when you look at the reasons for why there's this wealth gap and why, what happens in housing happens, there's just so many reasons for it. It's just like the list I gave on my slide is just barely touching on all of them. There's so many other ones. Like one of the ones I remember learning about in my master's program was like when they originally built the interstates, like the original interstates, the decisions about where they decided to build those, they basically decimated Black communities. They just chose Black communities to destroy. And they built them right through those communities, and those communities were completely disrupted. The owners didn't get value for their land, and the sort of health of those communities, the tight sort of connections and the networks and stuff, that was all destroyed when the interstate went through. And we're still reeling from the effects of that, and those decisions were very racially motivated, like how they chose where to build. So there are just so many factors to explain, why the housing market looks the way it does now.
Yeah, no, I agree. And I think you hit on people of color being higher percentage of renters, and then your work as a right to counsel, and the lack of success here in Alabama. We're faced with a lot of landlord-tenant calls every day, and one of my biggest issues is, I guess, the lack of tenants' rights in Alabama. It's very beneficial towards landlords only. And do you think that's been a big barrier to getting a right to counsel here? Is that there aren't, even with a counsel, there aren't a whole lot of tenants' protections?
So it's a great question. In an eviction case, if the tenant had no defenses, let's say either because of their particular case or because the law is that bad, there are three things that an attorney has to figure out in every single case. How much, if the tenant's going to have to move, that is. Let's say that the tenant's going to have to move because of the facts or whatever. How much time does the tenant get to move? How much rent is the tenant going to be adjudged to owe? Because that affects their credit significantly. And is this eviction going to be formally entered on their record or not? Those are extremely important questions that affect every single eviction case. So even if you have the worst law in the country, and many states do, besides Alabama, you still need a lawyer for those. Like the need for a lawyer is still incredibly important. And we also know that, even when there's bad law, there are a lot of evictions that are filed that are bogus, completely bogus. Like they're filed with no basis. And the only reason why landlords do that is because of that 3% tenant representation rate. They know they can get away with it. So they do. When you start providing counsel across the board, landlord behavior changes. That said, it's certainly true that the better the landlord-tenant law is, the more an attorney has to do. And when you see that success rate in New York City, where 86% of the tenants remain in their homes, a lot of that has to do with the law in New York. The lawyers have much more to work with there than they do in Alabama. Alabama has a pretty poor landlord-tenant law. Although I will say it can always be worse, because there are some states, well, the state we always give as an example is Arkansas, where not paying your rent is a misdemeanor, actually. So that is worse. And there are many states where a tenant is actually not allowed to, if a landlord files an eviction, they're not allowed to defend themselves unless they pay the entire amount of the rent that they're alleged to owe first, which of course is crazy. That completely denies them their day in court. But many states do that. They basically say you're not allowed to defend yourself unless you first pay all the rent into court. So there are just so many problems with the way that the landlord-tenant law works around the country. Alabama's is a problem. And actually before 2007, Alabama didn't even have a landlord-tenant law. It just had this kind of the Wild West of common law. But when it did pass its law, it weakened it significantly and took out some of the best sort of provisions that would have really protected tenants.
All right, I don't have any more questions. Does anybody else have any questions for John?
I'm happy to, I'll just drop my email address in the chat here, just in case anyone thinks of anything off after the fact. That I'll just say as a, sort of closing remark that on Heirs property, one of the real problems with heirs property has been getting legal assistance to tenants, because heirs property cases are long and expensive and complicated. Like, you don't solve those problems overnight, especially when you're talking about, many owners of the property. We've seen cases where there are literally 800 owners of a single property. I mean, that's just like an incredible, crazy scenario. How do you manage negotiating among 800 different owners? But even if you have 50, you're still talking about it's trying for a lawyer to try to get that many people together, let alone agreeing on anything, is extremely difficult. And so, and then, to form an LLC, to get all the owners into it, to fight a partition action, these are all very expensive, very time consuming things, and very few lawyers know how to do them. So it's, especially partition, it's not something that lawyers learn in law school. So it's just really it has been a difficult nut to crack to get legal assistance to heirs property owners, and legal services programs generally don't represent heirs property cases. They don't do them. So that's a problem that we're aware of. And there's a lot of conversation about how can we get more of those resources into communities so that owners can have help. What there is help with is writing wills. Mm-hmm. There are places that will hold will clinics where anyone can come and they'll help you draft one. And that is one of the best things that anyone can do. Even if you already have heirs property, don't let it get any worse. Don't let it become any more owners than it already is. That's, really so critical.
Okay. Well, thank you for your time and for all the information. I've learned a lot from you, and they're asking about the presentation. Yeah, the presentation is going to be available to anybody who registered. And we'll send out a copy of the slides. But yeah, thank you for this. It was great information, and I've learned a lot if nobody else did, but I think we're getting pretty positive comments here. So thank you.
Thank you, and pleasure to talk to everyone, and look forward to continuing the fight.
All right, have a good day. Thanks, everyone.